Great. Well, welcome everybody to our final event for 2025, likely at the NYU Center for Mind, Ethics, and Policy. We are delighted to be hosting John Adenitire and Raffael Fasel for a talk about animals and the Constitution based on their recently published book. So before we get started with introductions, I will just tell you a little bit about the center and about what to expect from the talk, and then we can get right into it. So the host of this event is the NYU Center for Mind, Ethics, and Policy. We do research and outreach and field building activities about the consciousness, sentience, agency, moral status, legal status, and political status of non-humans, widely, broadly construed to include animals, AI systems, and other non-humans about which or about whom these questions arise. So if you have interest in those topics, feel free to sign up for our mailing list and you can be in the loop about our research and other events like this that may be interesting for you. Now, this event is going to be a 75-minute conversation with the speakers, authors of this recent book. They will start by giving a talk about some of the main themes and arguments, conclusions in their book, and then I will facilitate a discussion which can include lots of questions, comments, objections, other input from the online audience. Now, as always, that will take the form of you entering your contributions in the Q&A tab on Zoom, and then I can present a curated set of questions, comments, objections to the speakers during the discussion that follows the presentation. So at any point along the way during the presentation, feel free to start adding your input on the Q&A tab. You can also upvote or reply to other comments that people are adding, and then I can draw from that when we have the conversation. Okay, with that said, without further ado, let me introduce the speakers. So first of all, John Adenitire is a senior lecturer in law at Queen Mary University of London. He completed his PhD in law at the University of Cambridge, and he is co-author of Animals in the Constitution, the book that will be discussed today. He also co-directs the Forum on Decentering the Human at QMUL, which I highly recommend following them and signing up for their email list as well. They do great work. And then Raffael Fasel is an assistant professor in public law at the University of Cambridge and a fellow of Jesus College, Cambridge. At Cambridge, he is co-director of the Cambridge Center for Animal Rights Law, which once again, I recommend following their work. They do great work. He obtained his PhD in law from the University of Cambridge with a thesis on the legal theory and intellectual history of human and animal rights, for which he was awarded the law faculty's York Prize. So, John and Raphael, thank you so much for writing this book and also taking time to talk with us about it. And whenever you feel ready, feel free to take it away.
Brilliant. Thanks so much, Jeff, for hosting us. I'm going to start talking, then I'll hand over to John in a few minutes. I'm sure he's going to thank you as well for making this possible, and to Audrey as well for all the work behind the scenes. So I'm just going to share my slides here because we've got a few slides for everyone to follow the presentation here. So really delighted to be here, and thanks all for joining this event. So as Jeff's mentioned, John and I published this book recently. I think it came out in summer in the States, and it's devoted to exploring what an alternative constitution, if you will, would look like. A constitution that didn't just cater for human interests, but that caters for the interests of all sentient beings. So that's the broad purpose of the book. Now, if you'd like to get a copy, you can use this discount code here. So if you type in AUFLY30, you get 30% off. You have to use it in the oup.com/academic online store, so it won't work on Amazon or similar stores. And the book is still going to be $91, unfortunately, but at least it takes down the price by a bit, and maybe some of you have direct access through their institutions. Okay, so that's AUFLY30 in case anyone would like to use that discount code. Right, so let me start by giving you an overview of the structure of the book. So the book is divided into two parts. It starts by looking at what constitutionalism currently is like, and that's anthropocentric constitutionalism. It's constitutionalism that is centered around and privileges human interests. It then makes the case for why we should adopt a different model of constitutionalism, and we call it sentience-based constitutionalism. And then in a second part, the book explores how different constitutional principles could be rethought, reimagined along the lines of sentience-based constitutionalism as we propose. So I'm going to talk briefly about part one, and then John is going to pick up some themes from part two. Okay, let me start by talking about anthropocentric constitutionalism, and I'm going to keep this short because John's told me off before for speaking too long about this. Now, in this chapter, we basically analyze and dissect and criticize what constitutionalism is like at the moment. So we start by considering legal systems generally and how anthropocentric they are, so how human-centric they are. They're human-centric, for instance, because many of them only recognize humans as having intrinsic value, whereas animals are sometimes only recognized as having instrumental value, so they're a means to human ends. Animals are subjected to a use paradigm, so they can be used as resources, they can be exploited for human purposes, whereas humans are never subjected to a use paradigm, as much as we may occasionally make use of humans, but they're never a mere means, if you want to use that Kantian language. Humans aren't property, they're legal persons, whereas animals are treated as property around the world. There's no jurisdiction in the world that has recognized animals as legal persons, although if you like in the Q&A we can talk about some of the really exciting litigation that is happening in some select countries that is questioning that property status. And then lastly, we're seeing human-centric concepts operating and really characterizing legal systems. So think, for instance, of the standard of the rational person, for instance, or the fact that legal personhood, as I just alluded to, is understood and conceptualized in very human-centric ways. So only humans can be legal persons, or corporations, but corporations ultimately arguably serve human interests. The chapter then looks at anthropocentrism in constitutional law specifically, as well as constitutional theory. And four of the main deficiencies that we're finding here are the fact, first, that animals lack fundamental rights. There's no constitution that guarantees fundamental rights for animals. Again, I'm going to add a small asterisk here. We can pick up in the discussion some interesting recent case law to that effect, maybe Estrelita in Ecuador, for instance. But for the most part, we can state that no animal has any fundamental rights in a constitution. The proportionality standard or principle isn't applied to animals in the way certainly that it is to humans. So for instance, when it comes to balancing rights, most jurisdictions use the so-called proportionality test. That isn't the case for animals. They don't get to benefit from that test. The rule of law is not centered around animals. They're usually it's centered around agential humans, and John is going to talk about that specifically, how that's problematic. And then lastly, animals aren't part of the demos. They're not part of the kinds of beings that get to have a say in democratic decisions. So these are four ways in which that anthropocentrism is manifested. And we go on, and I won't say too much about this here, to look at some promising developments that are happening in constitutions around the world. There are some constitutions that protect animal welfare, for instance, or in the Swiss case, that even recognize animals as being beneficiaries of dignity or holders of dignity. But we go on to argue that that still falls short of the kind of sentience constitution, or sentience-based constitution, rather, that we propose. So what exactly do we mean by sentience-based constitutionalism? So this is the second chapter that makes the case for why we should understand constitutionalism in a different way and move towards a new type of constitution that isn't just centered around human interests. So the way we make the case for this new theory of constitutionalism is by showing that anthropocentric constitutionalism, so the existing model, the existing paradigm, it suffers from a legitimacy gap. There's a legitimacy gap, And what we mean by that is that the current constitutions and the theories around those constitutions, they apply to lots of beings that don't actually have their interests covered by those constitutions, by those theories. So one of the main legitimating principles of sort of classic anthropocentric constitutionalism that we take aim at is this idea of hypothetical consent of the governed, which arose in the sort of late 18th century. So the idea that a constitution is legitimate and that constitutional rule can be, enforced against a given being if they have consented to being governed by that constitutional framework, or because that actually doesn't happen. In reality, very often the idea is one of hypothetical consent of the governed. As we argue, this is a problematic principle for two reasons. The first is it excludes animals who don't have the capacity to consent, who lack the understanding of constitutional rules that would be required for them to conceptualize, weigh different types of rules and then, consent to some rather than to others. And even hypothetically, we don't really think that would work because the idea of a hypothetical consent is ultimately premised on the idea of a rational agent, which in our mind, many animals certainly aren't. But the second problem is that this legitimating principle also fails to capture a lot of human beings. So we call them non-paradigmatic human beings in the sense that they're not the paradigm case for sort of classic constitutionalism. So they're the human beings who might be still, infants, for instance, or who are perhaps in a permanent coma, or who might lack the sort of agential capacities required to give consent, for any number of other reasons. So the legitimating principle that currently underpins constitutionalism basically cannot explain why constitutional rule still applies to all those human beings who, lack that ability to give consent, even just in a hypothetical way. So what we do to fill that legitimacy gap is to propose what we think is a more inclusive legitimating principle, and we call it the principle of due concern for the interests of all governed sentient beings. So very briefly, the idea here is to give due concern. So by that we mean to respect the basic interests. So it's a matter of not protecting, trivial interests, for instance. So we follow broadly Martha Nussbaum's account here of sort of core interests. So the example we give is, my cat has an interest in having her belly rubbed, but that's not really, a sort of a standard that a state needs to meet to be legitimate. It's about basic interests. And we're talking about beings that have intrinsic value. We think that sentience is a sufficient condition for having intrinsic value. There may be other potential grounds for intrinsic value. We don't really take a stance on this. We remain non-committal there, but we say that sentience at least is a sufficient reason. And then lastly, you're looking at a governed sentient being. That's quite important because we say that it's not all sentient beings, strictly speaking, that will determine the legitimacy of a state. So a state doesn't need to, or a constitution doesn't need to be concerned with all sentient beings, only those who are governed. And broadly, by governed, we mean, with sort of public officials having control over the life, the body and the habitats of a given being. So if you're thinking of very large states, for instance, maybe Canada or, Russia, Siberia, there may be animals that are on the territory of that state that aren't actually governed by the constitution. But many animals will be, and this goes too for factory farmed animals, for instance, because they are ultimately subject to a licensing and a property regime under the Constitution. So that's briefly by way of what we mean by sentience constitutionalism and how we make the case for it. I'm now handing over to John, who's going to talk to you about some themes from part 2.
Well, thank you to Raphael, of course, for handing over, but many, many thanks to Jeff and Audrey for the organization, and of course, thanks to the members of the public that are attending this talk, and it's exciting for us to talk about this new venture, our book that recently came out. And yeah, so let me carry on with where Raphael stopped, and to give you a little bit of the flavor of some of the chapters in the second part of the book. As Raphael said earlier, the book is divided into two parts. The first part really makes a case for sentience-based constitutionalism, and the second part applies this new paradigm, this ideal constitution, and we try to find out how we would rethink some of the fundamental principles of constitutionalism in light of this shift from an anthropocentric constitutionalism to a sentence-based constitutionalism. So we have four chapters in the second part. I'll only speak about two of them. And the first chapter in the second part is the one on fundamental rights. And the central argument of this chapter is that existing catalogs of fundamental rights can, in a sentence-based constitution, be read to protect the rights of animals. So basically that humans and animals can share the same Bill of Rights. There have been some efforts, for example, in Finland, to create new chapters or new articles in their bills of rights to extend constitutional protection to animals. We think this is desirable from a practical point of view because, of course, the Constitution of Finland, like most other constitutions in our day and age, is an anthropocentric constitution, right? So here we are not talking about anthropocentric constitutions. We are talking about this ideal constitution in a sentence-based order, right? So in this ideal constitution, we think that the same Bill of Rights can be used for humans and non-human animals alike, with of course exceptions, which we can discuss in the Q&A. And why do we think that the same catalog of rights can be used for both humans and animals? Well, we think that there are existing features, okay, of fundamental rights practice today, right now, even in anthropocentric constitution, that when rethought and when brought into the context of a sentence-based constitution, can justify our stance. So in the chapter, we talk about four features: the fact that fundamental rights and the holders of fundamental rights have progressively expanded. So in the US context, of course, the initial holders of the rights in the Bill of Rights was not a universal suffrage, especially the right to vote. But over time, the rights holder under the Bill of Rights has expanded. So we want to say that this feature of the practice of fundamental rights could justify us including animals within the same constitution that humans enjoy. The practice of fundamental rights also has another feature, that is that there is no hierarchy between right holders. What does that mean? It means that in principle, all those that are entitled to constitutional rights protection or fundamental rights protection enjoy the same level of respect. That doesn't, of course, mean, and I shall talk about this in a second, that all individuals enjoy all constitutional rights, okay, in practice at least. But it means that the catalog of rights in principle is devoted to respecting the interests of all the beings. So we think that this fact entails that, again, the same catalog of rights can be used for humans and non-humans alike. And so if you're worried about what I was alluding to earlier, that not all those that are entitled to the rights in a Bill of Rights will be able to enjoy all rights in that in that catalog. Let's think, for example, of the right to vote. Um, Infants, for example, or non-adults are not entitled to the right to vote. Well, we see that this issue is already covered by the over-inclusiveness of catalog of rights. That is that, yes, not all rights holders enjoy all the rights in the Bill of Rights. So it means that even though there is a constitution, say with the right to vote, we do not expect that the right to vote will be extended to animals alike. Though, of course, we do discuss in the book about a right to political participation and political representation, which we can discuss more in the Q&A. But I think this feature of existing fundamental rights practice shows us that we can use the same set of the same catalog of rights for humans and non-humans alike. And the final feature, the generality of the language of rights, okay, allows us then to interpret the rights in a way that is specific enough to different species. So we shouldn't be too worried that, say, a right to the right to freedom from torture, okay, or the right to bodily integrity will protect undue interests of different species, right? Because the language of fundamental rights in constitutions is quite broad, we can specify, or judges basically, or those that are in charge of analyzing and applying the Charter of Rights can suitably interpret the rights in a way that is suitable to their prospective rights bearer. In the book, in this particular chapter, after giving providing some of the reasons that I've alluded to now for extending bills of rights to our fellow creatures, we also exemplify this approach by talking about the right to life, the prohibition of torture and inhumane or degrading treatment, and the right to freedom. And we show how in a sentience-based constitutions, animals would enjoy these rights, and how enjoying these rights would fundamentally change the fabric of our society. And very happy to talk about that further later on. But let me move on to the next slide and give you a flavor of one other chapter in this second part of the book. That is the rule of law chapter. Okay, and in this chapter we are trying to reconceptualize again the rule of law, this ideal, this constitutional ideal, in a way that is suitable, okay, for a sentence-based constitution. And we think of the rule of law, or many theories think of the rule of law as primarily being concerned with the guidance of conduct. So we say that a state respects the rule of law when the law itself is clear, prospective, easy to understand, to enable humans to plan their lives, okay, according to law. Okay, but we find that this tradition, albeit very respectable, okay, is not really suited to a sentence-based constitution, which pays due regards to the basic interests of animals. That is, this this conceptualization of the rule of law basically excludes many animals, because animals are not able to guide their life and plan their lives according to the law. Okay. Of course, this may just be the case. Maybe it's okay to have a conception of the rule of law that exclude animals, but maybe we could be a bit more inclusive. So if there is another way to include animals, okay, or to include the basic interest of animals within the rule of law, then maybe we should explore that. And that's exactly what we do in this chapter. We argue there's a readily available alternative, a readily available alternative way of conceptualizing the rule of law, which is inclusive of animals. Okay, and this tradition is one that argues that the rule of law basic idea, the basic purpose of the rule of law is primarily about restraining arbitrary power. Okay, so arbitrary power is power that is unaccountable power. And we show in the chapter that there are many ways in which animals are treated arbitrarily. Especially, there are many ways in which we relate to animals, especially in factory farming, industrial farming, but also in many areas, which actually are almost devoid of legal standards. And we show that this is a deep problem for the rule of law. And of course, there are several traditions of conceptualizing the rule of law in formal, procedural, substantive accounts. Okay. And we show that the existing scholarship conceptualizes the rule of law in ways, whether this scholarship argues for a formal, procedural, or substantive account, in a way that unjustly exclude non-human animals. And by the way, also excludes non-paradigmatic humans as well, because just like many sentient animals, many non-paradigmatic humans, such as infants or humans with severe cognitive disabilities, are not able to plan their lives according to law. So we really argue for a more inclusive account of the rule of law, which protects all sentient beings, whether human and non-human alike, from arbitrary state and private power. And to give you a very practical example, in the book we talked about standing requirements, which have been an obstacle in a lot of recent litigation. Take the Non-Human Rights Project. Standing requirements have basically excluded animals from having their, so to speak, their day in court to protect their fundamental interests. So you can see that this account is not just theoretical, it's not just directed to, let's say, a legal theorist, but has a lot to say about the practice of law. Okay, so if we move to the next slide, that concludes, I think, the recap of the book, and we very much welcome the next part. Thank you.
Okay, great. Thank you both for that really interesting presentation. Obviously, a lot to discuss and unpack here, and we already have a few questions coming in from the audience, so we can go ahead and get started with those. And to the rest of the attendees, please keep in mind you can add any questions or comments or objections you might like to hear the speakers discuss in the Q&A tab on Zoom. So please do feel free to say what you might like them to unpack further there. Now, with that said, we can start with a question from Arthur, who would like to hear more, and I want to hear more about this as well, about your conception of governed sentient beings. So you noted that this constitutional provision would not necessarily apply to all sentient beings, but would instead apply to all governed sentient beings. And there are, of course, different ways that can be interpreted, ranging from a fairly narrow interpretation that might focus, for example, on captive and domesticated animals within national borders, and then a more expansive interpretation at the other end of the spectrum that might include all affected animals, whether captive or free roaming, whether domesticated or wild, whether in national borders always or migratory or in the oceans. and then various possibilities in between. So could you say a little bit more about how you understand that concept in this context? And is that an application of a familiar, like widely understood interpretation, or would this be you kind of offering to the legal community how you think they should interpret this concept?
Yeah, I'm happy to talk to that. So thanks for the question, Arthur. So I should maybe start by saying that our methodology is one of trying to sort of stake out what we call in line with roles, a realistic utopia, right? So, I mean, John's mentioned that, to some extent it's idealistic what we're doing. So that's the bit that's utopian. But as John's also mentioned, we're trying to say something that's also meaningful for practice and that isn't just like, a sort of a pure pipe dream. So to that extent, we're trying to be realistic. So it's a realistic utopia. So let's try to bear that in mind. So as to the concrete question, so chapter 2 looks at specific potential beings whose interests could determine the legitimacy of a constitution. So we start by saying, well, sentience-based constitutionalism, that means the interests of all sentient beings should, determine the legitimacy of a constitution. But we think that's too broad, right? So we're trying to be realistic here. We're saying that, it would just be impracticable for, say, the UK Constitution's legitimacy to be determined by, sort of the interests of, I don't know, a Siberian tiger somewhere in Russia, right? Clearly, that's too broad because the UK government can't do anything about the Siberian tiger. Okay, then we consider a slightly narrower criterion, which is the one that Jeff's mentioned, the all affected interest principle, which is a well-known principle in philosophical discourse. Here too, we think this is still too broad. It's a bit narrower than all sentient beings, but it's still too broad, we think, because we give an example to the effect of, I think the Constitution of Iraq has a provision on how I think basically a sort of income from fossil fuels should be, used and distributed. We say that, the use of fossil fuels affects animals around the world, right? So again, is the legitimacy of the Iraqi constitution dependent on, what it does to the interests of polar bears because of climate change? It's just really a sort of hard to make that case, I think. So it's too broad for our realistic utopian purposes. And then we end with basically talking about the all subjected interest principle. And to Jeff's question there, ours is basically a variation of the all subjected interest principle. So we think that animals are subjected to constitutions, but they're subjected in a particular way. We call it governed. We don't think they're subjected in the sense of being coerced, which is David Miller's formulation of the all subjected interest principle, which to our mind has too much of a sort of an agential flavor, if you like. You're coerced if you're really an autonomous being. We don't think that quite captures many non-human beings as well as non-paradigmatic humans, many animals and non-paradigmatic human beings. So therefore we settle on being governed and we define it as having effective control over those animals. I think there's some questions in the chat that we may get to later on as to whether that covers wild animals or not, but that's just to lay out the principle basically that we're using.
Okay, great. Maybe I can ask a quick follow-up, and then we have plenty of other questions we can get to. So one natural follow-up is, okay, please do say what you think about wild animals, for example, who are within a nation's borders and maybe within a particular state's or city's borders are obviously subjected to the practices and policies of the humans who control those areas, even though they technically are wild and free roaming to an extent. But then a related follow-up question is, I guess I would like to hear more about what your conception of practicality or realism is then, because if what you mean is we need to restrict this to a set of animals we can realistically hear their claims and protect their interests right now, then we might be back to like humans. and the occasional charismatic chimpanzee, but not, for example, farmed vertebrates. It would take a lot of work, and we would need to spend time building up that political will. So if there was a strong feasibility constraint, then it would be way too narrow in my view, and I think in your view too. But if there was a more generous or flexible understanding of practicality or realism, where, hey, we want to set an aspiration that we can like build momentum towards achieving gradually over time, then I don't see why the like tiger on the other side of the planet who is affected by our policies, whether we like it or not, should be out of bounds. So yeah, could you say a little bit about wild animals, and then could you say a little bit about what you mean by practicality and why this is a useful way of thinking about practicality?
Yes, they're great questions, and assuming John is still happy for me to take this one. So on the wild animals question, so we do sort of, flag as a possibility, Martha Nussbaum's argument that effectively there's no such thing anymore as nature. Humans control everything, not least because of, the sort of impacts we're having through climate change. We don't sort of ultimately, I guess, take a strong stance, but we say that, there's potentially a position that's a bit more pragmatic that does accept that there are probably some wild animals out there that truly aren't, governed in a more direct sense, as in having control over the life bodies or habitats. I guess that's where with climate change you could make an argument, to the opposite. But where we think it's a bit harder to make the case. So I gave Siberia as an example, or I don't know, northern Canada, or any other number of sort of really remote places. Maybe the deep seas as well. You could consider, to the extent that they fall within the territory, of a state, or states have direct control over them. So yes, there's going to be obvious examples. Domesticated animals are obvious examples of animals that we have direct, control over. So farmed animals as well, animals that we use for entertainment, all of that. With wild animals, so something that we do discuss is so-called culling campaigns that are conducted to eradicate what are considered invasive species. Now, those happen to animals that are so-called wild animals. And we do have control over their lives to the extent of actually eradicate them. We kill them. So there will be wild animals where we do have relevant control over, and by we, I mean, sort of, I guess, many states would have that control over. But we don't necessarily say we have to go all the way to Nussbaum's position where it just, this covers all animals. We do think that goes a bit too far. On the question of realism, I mean, I think that's, a very good challenge that you're raising, Jeff. And, maybe we're being still too utopian, for someone who wants to just focus on humans or maybe a few handful of animals.
Or
Yeah.
not utopian enough, to be clear. I
Or
would push you
exactly.
further in that direction.
Or not utopian enough. So it really depends on where you fall on this. We think that what we're presenting is realistically utopian, but we appreciate that people who come from it with a utopian lens might think we're being too realistic, and vice versa. So that's going to be a challenge. Now, I will say that what we're trying to do, and this is maybe more a response to the person who thinks we're being too utopian, rather than you, Jeff, who thinks we're not utopian enough. But it's worth flagging that the UK, for instance, has something called the Sentience sort of committee. So there's a piece of legislation, the Animal Sentience Act, that was recently created because the UK left the EU. And the main thing that it did that really made a difference, I guess at least on paper, was it created a sentience committee, an animal sentience committee, that is supposed to scrutinize governmental policy that's been created in light of whether it complies with animal welfare legislation, effectively with the interests of sentient beings. So the idea that you have a constitutional arrangement that is supposed to take into account the interests of sentient beings is not an entirely novel idea. It's to some extent already being put into place in the UK, albeit not quite to the degree that we'd like to see it happen. So to that extent, I don't think what we're saying is incredibly utopian. But yeah, I appreciate your point, Jeff, that you could say maybe we're not utopian enough, and that's just where we're trying to be realistic.
And actually,
And just Go ahead,
Yeah,
John.
sorry. Yeah, thank you. If I may add on this, remember that our our work is within a particular context, that of constitutional law and constitutional practice. So we want to build, even though we have goals as aspirations, yes, we still constrain from the context in which we write. So maybe someone who is writing in moral philosophy, they can go they can be very bold in the kind of claims that they make, right? But we also think we are actually quite bold, but we are constrained by existing legal practice and the rules of legal practice. For example, the all govern principle actually is and some of the criteria that we get in that actually derive from quite well established rules of jurisdiction, constitutional jurisdiction, right? So the realistic part of our utopia is basically trying to push the boundaries of existing practice, but without fundamentally changing the rules of the existing practice, right? And this is because we are writing within a particular discipline that has established practices, yeah, and we are not yet revolutionaries.
Yeah, interesting. I guess it depends partly on how you see the norms of constitutional legal scholarship, and then also what role you see yourselves as playing within it. You might think the rules dictate nobody can be a revolutionary, or you might think, hey, there can be space for more moderate and more revolutionary contributions, and our role is to make the more moderate contribution. There, of course, have been moments in human history where a constitutional text was used to state an aspiration that a country then had to work over the course of generations and centuries, like all men are created equal, in order to approximate making good on. So there can be some space for that revolutionary spirit, but that might not be this project. And fair enough. It already is quite ambitious, as you say, to include any animals at all in a constitutional text. Now, one other question in this direction, and then again we have plenty more. And John, I would be curious to hear your thoughts about this, especially because you and I have spoken about this in the past. David asks, do you think there is agreement about who is a sentient being? And just to unpack that a little bit, I will go ahead and say there is not agreement about who is a sentient being, nor is there certainty about who is a sentient being. There is a lot of disagreement and uncertainty about that question. And for that reason, some folks in the literature, including me, have pushed for thinking about this question less in terms of yes and no, all or nothing, and more in terms of evidence and probabilities, and extending proportionate consideration to individuals who have at least a realistic possibility of being sentient given the evidence available. Now, I guess one question is, what kind of standard would you suggest for a constitutional provision, like a being who is certain to be sentient or at least very likely, given the evidence, in which case we might be focusing on mammals and birds and select other animals, or individuals who have a realistic chance of being sentient given the evidence available and who are governed and controlled by the relevant government, in which case we might be talking about a much more expansive category of captive and or wild animals who are controlled by the relevant parties, and that could include all vertebrates and many invertebrates potentially. So how are you thinking about that?
Yeah, this is a great question. It's made even great because it really points the finger at disagreements that exist not only within the existing literature, but that exists between Raphael and myself. So we for sure are not in agreement about whether all animals are sentient, okay, about which animals in particular are sentient. We're actually having that discussion between ourselves just the other week. And in fact, we are not even sure what sentience means. About the concept of sentience, we are not in agreement about whether it's for example, is a gradual property or whether it's a binary property, and we have had some discussions about that. Nevertheless, again, because here we have to think about the context in which we are writing, and I'm sure Raphael will intervene to correct me about whatever he may disagree with. I I am very attracted from a moral philosophical point of view to the view that, when there's uncertainty about whether a certain animal is sentient or not, then we should afford them a proportionate amount of moral respect. Yes, I think in moral philosophy that's very helpful, and maybe in personal ethics, if I'm not really sure whether a particular worm that has 500 neurons, whether this worm is sentient or not, there's no reason for me to step on the worm and to crush the worm. So as long as it doesn't really it doesn't affect my life in significant ways, I can defer and not interfere with presumed interests that this worm with 500 neurons may have. I think sometimes the law may need to have sharper lines, because sometimes the stakes are much higher, and it's sometimes it's about granting fundamental rights. Okay, so the law has to be sufficiently general, prospective, knowable, and so we may need brighter rights, brighter lines, and we may not be able to act in probabilistic terms. So a judge needs to know, okay, does this worm have a right or not? If it has a right, then you cannot build a dam that will destroy its ecosystem. But if it doesn't have a right, then you can do whatever you want with the dam. So I think I have more questions than answers. So maybe Raphael is a bit more brave, but they're really the issue of sentience, and I think that's why you have a research center that is devoted to, among other things, this issue. Who is sentience? What is sentience? What are the moral, constitutional, political implications of sentience? Are really intractable problems. But nevertheless, there is some agreement, right? Because we know that your dog, Raphael's cat, someone's parrot are sentient. There may be borderline cases like the worm with 500 neurons. Yeah, so in those cases, we don't know how best to approach.
Yeah, great, fair enough, and I agree. There do need to be brighter lines and simpler rules in the law, given that the law is a blunt instrument than, for example, in personal practical ethics. I do still think there could be a space for probabilistic and proportional approaches to these questions because, for example, there could be different weights given to different rights, and they could take more or less priority in multi-factor decisions depending on the probability that that right is really deserved by the individual. But this is a much longer conversation and no need for us to get to the bottom of it right now. Thank you for your answer. We have some other related questions too, and one that might be worth unpacking now comes from both Martin and Dayton, which is about how your work relates to, and how your argument in this book relates to Sue Donaldson and Will Kymlicka's view in Zoopolis and other work. Of course, Donaldson and Kymlicka argue that animals ought to be regarded as having political rights. And as you know, they make a distinction between domesticated animals who ought to be regarded as having citizenship rights, and then at the other end of the spectrum, wild animals who ought to be regarded as having sovereign rights. And then in between, liminal animals like urban animals who ought to be regarded as having denizen rights. And in more recent work, they have also, and lots of other people, Dayton notes Eva Megere, Pablo Costello, plenty of others, have explored how animal agency can be better recognized in the law. Now, you note that animals might not have a specifically human kind of agency with human language and reason that would allow them to plug seamlessly into our political processes and be representatives and full participants in the standard way. But there has been a lot of discussion about how, nevertheless, they do have their own capacities for agency and they do express their own preferences. And we could make more of an effort to study their revealed expressed preferences and take that into account when making decisions that affect them. So I just wonder, first of all, how you see your work in relation to Donaldson and Kimlicka, and second of all, how you see animal agency as relevant to proper consideration of animal interests.
Yes, thanks for that question. It's a really good one. So I'm happy to answer it, or at least try to. So, I mean, sort of seen from afar, we're doing something quite similar to what Sue Donaldson and Will Kimlicka are doing. We have a chapter on democracy, as I said. We do propose that animals should have an equal right to democratic participation, right? So in that sense, we're part of the political turn in animal ethics, animal law, if you like, as much as they are. And obviously we owe a lot to their terrific scholarship. I'm personally very much looking forward to reading the new book, which I think should be out, shortly, and maybe Jeff's already seen it. So that's as far as the sort of commonalities. There are some differences. So it's fair to say that we belong more to the sort of cosmopolitan camp of this, sort of scholarship. So we're perhaps more in the tradition of Alistair Cochrane here than in the line of work that Donaldson and Kimlicka pursue. So we don't distinguish between different categories of animals in that sense. We don't distinguish between sort of wild, sovereign, and liminal and domesticated animals. The category we work with is governed sentient beings. So if you're governed, then you're governed. And we don't think that, I don't know, just because you're a wild animal, you have fewer protections applying to you. And for that matter, fewer obligations. We don't look at it through the same lens. Now, I will say more on the point of how we agree with them, but potentially also disagree slightly. So in the chapter on democracy, we argue that animals should have an equal right to democratic participation. And we basically take a bit of a middle ground approach. So Kimlicka and Donaldson, as well as others that have been mentioned. So Eva Meyer, for instance, Charlotte Blattner would be another one we could mention here, another great scholar. So they argue that animals are political agents and that, democratic systems should be, attuned to their voices. And we think that's true to some extent, but we think that it slightly sort of overstates the point. Because we think that animals have agency, non-human animals that is, in many important respects, but they don't have political agency in the formal sense. So my cat doesn't have what it takes to run for office. Simple as that. My cat doesn't have what it takes to, vote on any given, proposition, say. So animals are agents, clearly, but they're not, most animals for that matter at least, they're not political agents in that narrow formal sense. Now, what we think that sort of people miss who are in what we call the political patience camp, so people like Janneke Vink, for instance, they say, well, animals lack agency, and therefore it's basically just humans who have to look after their interests, but they can't play a role in politics at all. We think that's sort of the other extreme that gets it wrong too, because they're ignoring the fact that animals are agents, just not in the formal sense. So we propose a sort of a middle ground where we think animals should have a right to participate in democratic decision making, but by that we don't mean that they get to participate in any direct votes or a sort of run for office, but we mean that their interests should they should have a voice in even telling us what their interests are exactly. So no matter what, we're going to need human representatives for those formal political processes. But we should listen to what Donaldson and Kimlicka and others are telling us about the agency that animals have to sort of shape political spaces, I guess, in a broader sense. So that's just to sort of hint at what our sort of middle ground position here is. But chapter 6 tells you more about it.
Great. And actually there were some other questions that are now perfect follow-ups to your answer to this question, because, for example, Herb asked about Christopher Stone's emphasis on assigning a guardian to assert and sue to protect the interests of animals. rather than trying to claim rights for animals directly. So there is, I guess, one question here about whether assigning guardians to represent the interests of animals could be seen as an alternative to attributing rights to animals and then adjudicating those rights. But a broader question that I would also love to hear you address following your answer to the question about agency and political participation is what kinds of mechanisms and offices and representatives do you think could rise to the occasion and faithfully represent the interests of animals and decisions that affect them while listening to the animals in an appropriate way? Of course, there have been a lot of suggestions ranging from animal welfare offices and discussion of these issues in citizens panels or assemblies, all the way to more ambitious, formal, official approaches like creating a bicameral legislature with one house that includes human representatives of the typical type, and then another house that includes guardians or people who are trying to represent the interests of not participating stakeholders like animals and future generations. So just curious if you have a concrete specific proposal about how this will be implemented, how it will be represented, or if you see your role as offering the constitutional principles, but then leave it to someone else to figure out all of the practicalities.
Okay, I think I'll take the first part of the question, and then Raphael can take the second part. The first part of the question is about is the one that Herb makes on Christopher Stone's guardianship. I see at least in a constitutional law context, I see that as it is some of the premises of the question as questionable. Because even on a guardianship model, really, the guardian is there to enforce certain things, right? Which are, and in the context of constitutional rights, they are rights. So if animals are recognized as having constitutional standing, okay, of course they themselves cannot go in front of a judge. Raphael's cat cannot go in front of the judge and claim something, okay. But the constitutional provision would be, say, Raphael's cat as a right to life, or Raphael's cat as a right not to be tortured, okay, for no yeah. And so this is the interest that would be recognized in a constitutional text, directly or indirectly, or through a constitutional adjudication, right? And of course, because the cat cannot go there and claim, for example, that they have been tortured, and claim damages, or claim another constitutional remedy, then there would need to be a kind of a legal representation for that. And in fact, this is actually not that very different from what already happens today. So say that there is a child, like an infant, that has been domestically abused, whose constitutional rights say have been infringed because an agent of the state maybe tortured them, or tortured their parents, and caused them constitutionally recognized harm. Now, this infant cannot go in front of the court and start making claims, because probably they don't have the necessary capacities, knowledge, etc., language skills to make these claims. But their interests are protected by the Constitution, we assume, and they need a legal representative to make those claims for them. And in fact, even adults, like who have legal knowledge, like you and I, and by you and I include Raphael and Jeff, and myself a little. Even those with legal knowledge, we still don't have adequate knowledge to go in front of a court to make the claims that sometimes are made, and we need someone to speak on our behalf. So I see that question as some of the premises being maybe unclear for the context of constitutional adjudication.
Yes, and maybe just to add briefly to that, I don't think it's an alternative really to pursuing fundamental rights for animals for the reason that John's mentioned. So if the premise of the question is, well, it's hard to get fundamental rights, so at least let's get legal standing for animals. Well, even if you get the standing, what are you going to do with it? It's just a procedural device for you to enforce something. But if the thing that you're trying to enforce isn't really there, fundamental rights, then you're just going to enforce welfare legislation, and that may be better than it being, not enforced, but it's not going to get you to fundamental rights. So on the second question, it's a really good one. So one part of the answer would be, yes, we'd be in favor of, legal representatives being created for animals. There are different, examples for this, different ways and sort of shapes and forms this could take. We don't sort of go into in too much detail, but Switzerland, for instance, used to have an animal attorney that was part of the sort of state. Ultimately, it ultimately got abolished, but they were a legal representative of animals that could appeal court decisions if they felt like the animal's interests weren't, protected sufficiently. Then we have countries with the private prosecution, the UK, for instance, the US to some extent too, as I understand. So the RSPCA in the UK, until recently at least, was bringing a lot of cases. So any number of different systems would be possible. We don't really, make the case one way or the other, although it could be an interesting follow-up piece to go into some more detail on that front. So that's one thing, the legal representatives. But the democracy chapter that I mentioned earlier also talks about political representatives, and this goes to Jeff's more specific point. So we do actually propose that there should be what we call sentient beings representatives in parliaments. And we sort of, make the case for these reserved seats. We say probably roughly around 30% of seats should be reserved to sentient beings representatives. We say, there's no sort of strict maths here, but 30% usually allows you to veto really important decisions, at least. It's an important number in terms of forming coalitions as well. So it's not 50%, but it's not nothing. So we're trying to be, again, realistically utopian here. These sentient beings representatives, just to flesh it out slightly, would be elected by so-called deliberative selection assemblies. We're drawing here on Alistair Cochrane's work, who in turn would be chosen by lot and given advice by relevant experts in the field. So you have those representatives who will be chosen by this assembly that's informed through experts and chosen by lot. That's roughly the institutional framework that we sketch. But again, as I say, it's really just a rough sketch.
Excellent, excellent. Now, just one follow-up question, which returns us to our previous discussion about practicality and realism, and then we should have time for one or two more questions from the Q&A as well. So even with, for example, farmed vertebrates like mammals and birds, cows, pigs, chickens, fishes, there are billions and billions and billions of them farmed annually, often even within particular geographical territories. And so even if we focused on the animals who are the clearest, most paradigmatic cases for inclusion in your constitutional provision, right? Like very likely to be sentient, clearly governed and controlled in the relevant jurisdiction, there would still be so many of them. And they would be enduring such clear injustices, at least at this stage in human history, that it would clearly overwhelm the courts for their claims to be heard in the ordinary sense, individual claims being heard in individual cases. And that clearly is on the minds of judges who are hearing non-human rights cases for individual elephants and chimpanzees. Even if the case in front of the judge is about an individual elephant in the zoo or an individual chimpanzee at a roadside zoo, clearly the judge is thinking 2 or 3 steps ahead about if these arguments were accepted and appropriately generalized, what would follow for the farmed animals and the lab animals. And clearly the courts would be overwhelmed. We already feel overcapacity. We have no ability to handle this many real claims from entities that deserve to have their claims heard. And so I think then the judges are just moved to stop this slippery slope by denying that even this one elephant or this one chimpanzee has this one right. Now, I assume you think that is not the right way for them to to reason about this. But I assume you also acknowledge that it would be very difficult for the courts to hear all of the claims that would warrant being heard if we all agreed that these animals had standing for their basic rights. And so I just guess I would love to hear a little bit more about how your practical utopianism would operationalize this, even for the farmed cows, pigs, chickens, even set aside the fishes, just the farmed land vertebrates. How would you make it feasible? Would you turn everything into a big class action lawsuit? What would you do?
Yeah, that's that's a great question. I'll try to have a go at it, and then Raphael can intervene as he pleases. Mm, yeah, of course, we think it would be very impractical for every individual animal to have to bring a suit in court to enforce their rights. And we don't expect that. And even in the history of human injustices, say slavery, etc., we wouldn't expect each individual human that is the object of injustice to have to go to court individually, right? That's the whole point of having a constitutional provision, right? And the law in general. That is, the generality of law applies here to a class of persons, a class of individuals, a class of subjects. And that's why you're totally right that courts, when the Non-Human Rights Project comes in front of them and tries to pretend, or maybe they try to manage their cases by saying, hey, this case is really about this chimp, and only this chimp is only about this elephant, and only this elephant.
Yeah.
Clearly, not many people will buy that argument. And by the way, I'm a great admirer of the work they're doing, and I know Jeff, you've also been involved in some ways with that work. So this is not a critique, but the critique is that we cannot escape the generality of law and the precedential value of constitution, especially constitutional cases, because constitutional cases make law for the whole territory in many, at least in the US context, right? So I guess there are ways in which we can move from a anthropocentric constitution to a sentience-based constitution without having all individual animals. Like the most, one clear way is for what you've talked about, maybe constitutional cases to be brought by maybe a class of animals, and that the logic of those cases is then extended to similar cases. Yeah, that would be one process.
Okay, great. So there are several more questions. We may have time for one or two, but how about we start with this one and then see if any time remains. So a very simple, concrete, specific question that calls for a very simple, concrete, specific answer from David. What is some language that you would suggest be in the Constitution? So if the founding fathers, the founding parents of a new country approached you and said, all right, we want this to be short and sweet, but we will give a sentence or two to the interests and needs and vulnerabilities and standing of sentient beings. What would the sentence or two be that they should include in the Constitution?
Raphael, you want to take this, or do you want
I
me
can
to
take this one. I mean,
Okay, cool.
it covers what John said earlier. I think most of the language would not need to change. Maybe we wouldn't need to include new language because of the reasons he pointed out. If it says right to life, you can interpret that as applying to all governed sentient animals. Most constitutions don't say the human right to life, they just assume it's the human, and that's problematic. But because they don't explicitly mention the word, then that means the language actually doesn't need to change. Now, to the extent that constitutions are more explicitly framed around human beings and the term is used, then that's a problem, and we think it should be replaced with, sentient beings. But in fact, quite little intervention is necessary as far as the text of constitutions is concerned.
Now, okay, follow-up question for me, and I am going beyond my own expertise here, so please educate me. I would assume that even if a constitution does not specify that it is referring to humans, once 100 years, 200 years of judicial interpretation is baked in, then you might need something like an explicit constitutional amendment, novel constitutional language, in order to overcome centuries of calcified interpretation according to which this actually does refer to humans. Do you agree or disagree with that? Am I right or wrong in assuming that that might be needed in that sort of situation?
Yeah, I mean, I think that's a fair assumption, right? And I remember when I was talking about the Finnish experiment, where in Finland, just in the past few years, they have been trying to introduce a constitutional amendment to make sure that the fundamental interests of animals are protected by the constitution. And of course, we engage with that project in the chapter on fundamental rights, and we acknowledge, look, as you say, Jeff, the current constitutions are anthropocentric. There is an understanding, an implicit understanding, that when a constitution says all persons are subjects with rights and dignity, they don't actually mean all sentient beings, right? When they talk about persons, they really talk about humans. And so, yes, in this context, a constitutional amendment can undo, or a constitutional addition can undo this. But nevertheless, in a sentience-based constitutionalism, constitution, one which has a different paradigm, we still think, because of the shared interests and capacities that humans and animals have, right, that when the constitution says all beings have a right to life, that or all persons have a right to life, that can be suitable interpreted to include animals as well.
Can I also just add, and I appreciate this might mean we don't have time for an additional question, but
All good.
As much as the book, for the most part, is at the reasonably theoretical level, as listeners may have gathered by now, or viewers, this is ultimately a project that's very much open to different jurisdictions approaching their, sentience-based constitution in different ways. So, to Jeff's question, there are constitutional systems like that of South Africa, for instance, or Kenya is another example, that are explicitly based on the idea of transformative constitutionalism, right? So it's baked into these constitutions that they have this dynamic rights protection element built in, the sort of expansionism that John's mentioned earlier. So in these constitutions, you may not necessarily need a constitutional amendment. David Bilchitz, for instance, a scholar and a former constitutional court judge from South Africa, makes that case. He thinks animals should be granted dignity or recognized as holders of dignity and fundamental rights under the South African constitution as it is, right? But then there's going to be jurisdictions that don't follow that model, where I think you're right, a constitutional amendment may be necessary.
Excellent, very clear, and that makes a lot of sense. And that does take us right to the scheduled end, and I want to respect everybody's time, so we will stop there. Though, FY, everybody, we will share your questions with John and Raphael after the fact, so even if they might not be able to respond to them directly, they will see them and be able to take them into account. So let me just close by, first of all, thanking John and Raphael again for working on this issue. The issue is extremely important, neglected. Your work is really, really important, and hopefully will have all of the influence that it deserves. And I also just want to thank you for taking the time to talk with us today. The talk was really interesting. I loved the conversation. It seems that many people in the chat did as well. So thank you for that too. And yeah, everybody in the audience, thank you so much for taking time out of your day, especially folks who are really busy at the end of the academic semesters. I really appreciate your taking the time to participate in the conversation. And finally, a thank you to some of the people who made this event possible. The Center for Mind Ethics and Policy hosted, but we had quite a few co-sponsors for this event, including NYU Animal Studies, the NYU Wild Animal Welfare Program, the NYU Center for Mind, Brain, and Consciousnness, and the NYU Center for Bioethics. So thanks to all of you for supporting the event, and finally to Audrey for doing all the work to make it happen behind the scenes. Audrey Becker, our center administrator.
Thanks, Jeff, and thanks everyone for attending.
Thank you so much. It's been a great pleasure. Thank you.
Okay, thanks everybody. Have a good rest of your day.